Muy buenas tardes, bienvenidos sean de
Good
regreso a este
afternoon.
segundo día,
Welcome
a este
back
tercer
to
día del
the
segundo Foro
third day
Internacional
of the
de
second
Innovación
International
en la
Forum
Justicia.
on Justice
Ahora
Innovation.
continuaremos en nuestro
Now we
panel
will
de justicia
continue to
abierta.
our panel of
Modera
open
Jorge
justice.
Carvajal,
This will be
investigador
moderated by
del
Jorge
Programa de
Carvajal,
Justicia de
a
México
researcher
Evalúa,
of the Justice
y
Program of Mexico
participan
Evalúa, and we will have
la
the
ministra Ana
participation
Margarita
of
Ríos
Justice
Farjat,
Ana Margarita
de la
Rios
Primera Sala de la
Fayad
Suprema
of
Corte
the
de
First
Justicia de la
Chamber of
Nación,
the Supreme Court
Alvaro Herrero, de la
Justice
Red
of the
Internacional de
Mexican Superior
Justicia
Court of
Abierta,
Justice. Then we
María
have
Barón,
Alvaro
de la
Herrero of the International
Fundación
Network for
Directorio
Open Justice,
Legislativo
Maria
y
Barana
del
of
Comité
the
Directivo de la Alianza para el
Legislative
Gobierno
Directory
Abierto,
Foundation and of the
María del Carmen
Steering
Nava
Committee of
Colina,
the Alliance for
del,
Open Government,
del
and Maria del
Info
Carmen Navacolina
CDMX.
of Info
Le dejo la
CDMX.
palabra a Jorge
I
Carvajal.
will give the
Muchas
floor
gracias.
now to Jorge Carvajal. Thank you very much. Good afternoon. I am Jorge Carvajal. I am a collaborator at the Justice Program at Mexico Evalúa. And it's a pleasure for me to be in this panel, in this forum, to speak about a topic that I am passionate about. And this is a topic that, without a doubt, open new perspectives and horizons with regards to justice. And here we're speaking about open justice. I greet the panelists, Justice Ana Margarita Rios, Maria Barran, Maria del Carmen Nava, and Alvaro Herrero. In this panel, we will address the topic of open justice, and we know that it has got different perspectives. I would like to start with a reflection with some data that I think are at the core of what we can expect to be addressed by open justice and an open state. These are deep matters that are very rooted in the justice matters of our country. According to the Latino Barometer, Latin America shows a high level of skepticism with regards to the judiciary. From 1995, the trust percentage in this institution does not reach 40 percentage points, and it goes between 17 and 23%. For the last measurement, it reached 25%. This report says that there is weakness in the region's justice, and this significantly affects democracies. Furthermore, there is a perspective that the judiciary is considered one of the least scrutinized public powers. The judiciary is considered as a conservative, formalized, hierarchical branch of power, and therefore, in here we're speaking about trust, effectiveness, and efficacy of these institutions. When we speak about an open state, we can speak about a new paradigm in the exercise of civil service based on the principles of transparency, citizen engagement, accountability, and innovation, with which we aim at building governance, transparent governance models, and also justice which is accountable and responsive. Open justice comes after an open state focused on the judiciary, and the open parliament, which focuses on the legislative power. To recover some data on the progress in terms of the disaggregation of the approach, the policies, and open state practices worldwide, we can start from this milestone of 2011, which was the statement of open government, upon which the Open Government Alliance was founded, and of which Mexico was a founding part. Today we have 58 countries and 76 jurisdictions or local government. We can also see that stemming from an instrument and a central tool being used for the processes promoted by this alliance, which are the action plans for open government. From 2011 to 2018, 132 engagements between the authorities and the civil society and the society stakeholders took place. Out of these 132, well, they represent 80% of the total, and they are related to the topic of justice and open justice. This is a relatively low number, but we do have antecedents of this practice. The justice field establishes conditions and specific challenges for the incorporation of the rule of law approach. When we speak about open justice, what do we mean? Well, with regards to solutions of disputes and addressed by the judicial system and the guarantee of rights and the administration of justice, or in the institutional openness. Also, we have to consider, and this is an approach we use at Mexico Evalua, that justice systems, especially in criminal matters, cover not just the judiciary, but also the public prosecutor offices, the public defender offices, and the prison system. In this panel, we will be addressing specific topics related to the challenges and the relevance of open justice for the creation of a more effective and transparent justice system, the transparency principle, and what new tools can facilitate access to judicial information. We will be speaking about the judicial information and its relevance in the promotion of the participation and the citizen knowledge. Public knowledge, which and socially useful public knowledge, and also the legal language. We have seen this topic a lot in other panels. For instance, that of vulnerable people. We spoke about the barriers with which they are faced and the good practices of open justice in the region. This panel will be developed through two presentation rounds of 5-minute turns each, and we're going to be using as a benchmark some questions. I will give the floor first of all to Justice Ana Margarita Rios. She's an attorney of the School of Social Sciences and Law of the University of Nevada. She has a master's degree in fiscal, and she is a master's at public policy by the Technological Institute of Monterrey. She has over 2 decades of experience and professional exercise acknowledged in several institutions throughout her career. In December 2021, she was appointed Justice of Mexico Supreme Court of Justice. And I would like to have as benchmark justice, the way in which the principles have been taken and adapted to the judicial part. I mean, open justice principles and how open justice relates to human rights. The floor is yours for 5 minutes. Thank you very much, Jorge. I'm going to take a little bit more, some of these 5 minutes to greet those who are with us today: Maria Baran, Alvaro Herrero, Maria del Carmen, and all the people who are following us and that have been following this forum. Before coming in, I did not have the opportunity to tell you that I am very honored to take part in this forum, and it's an honor to be with all of you. You were mentioning in your introduction, Jorge, this new management of open government is a new governance way, and maybe the last resources of the state in which the philosophy and the open government philosophy has completely transitioned to, and this is the judiciary. Maybe I don't think it's because of a reluctance or any inertia. Undue inertia, if we had basis to consider this as undue, let's say an institutional reluctance, as this could be the case in other institutions. So rather than a reluctance because of this, we do have some kind of a jealousy with respect to the work, the information with which we work. We have methodologies here, and the matter of associating the justice apparatus loneliness to the fact that there may be a lack of agency. That does not mean that we divorced the principles of injustice. I think we are headed this way, but I think there are very important challenges, and we can differentiate them maybe in terms of judicatures, the federal one on the one hand and the local justice on the other. And I think that I can have here some generalizing basis that justice entails, but I think that local justice is lagging behind with respect to direction towards the open justice principles. Now, if open justice is about linking the citizen participation, so participation, collaborative work, policies are created, and not just transparency and accountability, but to achieve social, sensitive, effective justice that society feel its own, and that can be, and for them to deploy their rights to justice, it's necessary for this communication with society to exist. The judicature cannot act as if they were divorced from the society within which it must administer justice in terms of what society has agreed for it to be. Society has to gauge it, and society changes in a way that we always have this understanding, and not just transparency per se. So in order to achieve this right to justice, we need transparency and accountability, collaboration, and civil participation. We have a lot of challenges here. And I was mentioning this in another intervention. According to me, we have to see the local and federal justices journeys. It's easier to follow the local justice, and it has very visible aspects for which through which we can measure them, because the hearings of Mexico Superior Court of Justice are public, and I think that's an important differentiator. And we have differences here. The risk of being speaking with regards to people when people who are going to be, and not just as is going to be debate, closed door debates. We have access to information, and how we are going to be considering this. I'm not sure if I have another intervention, because I'm not sure if I think I see that I have a clock there. I think I've used all of my time. Yes, you will have another intervention there, so we can stop here and then we can move to the next intervention. And now, very well then, thank you, Margarita. These are very clear topics indeed with regards to the need and the convenience of adopting this focus in the judicial practice, and also in terms of the challenges that we are going to be addressing now. Now I will give the floor to Maria Baron, who is the executive director of the Legislative Director Foundation. She's specialist of international relations by the University of Bologna. She's a PhD candidate in political science at the San Martin National University, and she has worked at civil society organizations in Argentina and abroad in order to decrease the anti-ethical practices by civil servants. And she has published 7 editions of their works, who legislators are and how do they represent us, and domestically and in other districts of Argentina. I give the floor now to Maria Baron. Welcome. Thank you very much, Jorge. First, I would like to greet, of course, my colleagues at this panel. First of all, Justice Rios, and of course, Alvaro Herrero and Mary Carmen Nava, great colleagues with whom I work a lot, and in open justice governance. I can start, or do you want to make me a specific question? Well, let's go back to the first question of the challenges. Right? Yes, how the open justice principles have been adapted to the judicial field and how they relate to human rights. I would like to take one step backwards before with regards to the context of open government, the alliance for the open government that is going to turn 10 years this year, since it started in 2011 with those presidents who were fostering this agreement between different countries. And you were saying this before, we have 78 and 10 years ago only, we started to speak about open government and transparency and accountability. Today, in many of the countries, including Latin America, we're not speaking about open government, we're speaking about civil space, and we're speaking about free and fair elections. So I think that for me, that's what it is, what the world has become, not just in terms of the pandemic, but that's the context where we are now. Open justice, we can work on that as well, but that's the other scenario, the more difficult scenario. So that's the context, and also CSOs are the counterpart in a more critical footing. And to go to your question, and as not to repeat what Justice Rios was saying, which is the work that we have been conducting from the Legislative Directorate in the region, in which we consider everything that concerns the legislative initiatives and the implementation of regulations. Also, we have the principle of this from the beginning of the Alliance for Open Government, and we can say that the members of the Alliance in the region executed 105 regulations which concern anti-corruption, transparency. These are laws for the improvement in the access to information, against lobbying, final users, and so on in the region. At least in these last years, we executed 150 norms.
Now, if we ask the civil society organizations that work in this area, the organizations feel this debate that is being done is that we need more. And more than 150 regulations, and there is also a gap, which is something that we have since before the pandemic, not only with regulations against corruption that are also related to the short capabilities that the region has to implement new regulations. I think that's one of the greatest challenges, and it includes the legislative and judicial branches. And also, I think that the greatest challenge is if this space is useful for us or not. And I think that for the governments and civil society, yes, this space is useful, but we need more. It's better to have than to not have. And regarding human rights, and I will finish with this because I know I only have 5 minutes, we can trace a line before and after the pandemic, and actually in our experience, which is the 5 rights that are related to the civil space in almost all countries, which are reduced areas because of the pandemic, today that we are not in the beginning, we have not gone back to the place where we were before the pandemic in terms of rights. So to conclude with an idea, in this moment of increase of the systems and debts related to institutionality in the region, we have some old debts that are presented as great challenges. The human rights issue, or the civil space issues. There are a lot of organizations working here, and we are expecting not only civil society organizations, but also we expect to have more responses, and we need to see how to do that. Thank you very much. Thank you, Maria. Yes, indeed. When we talk about direct justice and opening procedures, we need to talk about the will and the commitment that is done from the different institutions, and also the civil space and the civil society stakeholders, the non-government stakeholders that make this effective. So I think that the things that you're mentioning are important because that's how we build conditions. Well, to continue, I will give the floor to Alvaro Herrero. He's an expert in governance, transparency, the rule of law with experience in Latin America. He has worked nationally and internationally with NGOs and different international organizations such as the Inter-American Development Bank. And he has been consultant in different programs such as the UNDP, the USAID, also the IDB and the World Bank in more than 15 countries in Latin America. He was executive director for the Association for Civil Rights, and he was also in the board of the Laboratory of Public Policies and Citizenship. He was also the Undersecretary of Strategic Application and Institutional Quality in Buenos Aires since 2015 until 2019. It is a pleasure to have you in this panel. The floor is yours for 5 minutes. Good afternoon, Jorge. Thank you very much for the invitation, and as well as my colleagues, it is a pleasure for me to be here in this panel and in this important and necessary event to elaborate on the discussions about innovation and justice. I totally agree with the comments of my colleagues, and I wanted to share a slide that is related to your question on how the principles of open government adapt to justice. And I think that the good news is that there are a lot of facts and there is a lot of experience that we have in the region, both in Latin America and the Caribbean. And I think that with this experience, we have the challenge of collecting it and applying it to the justice systems in the region, to the civil society organizations and the academy. I think that there is a first generation of reforms of open justice, and we didn't call them like that 10 years ago when, as Maria mentioned, we created the Alliance for Open Government. We were talking about reforms of institutional quality, institutional strengthening, or reforms that went with the judiciaries, and then the transitions to the democracy that different countries underwent in the 80s. And there we have the three pillars of the open government: transparency, citizen participation, and collaboration. And we could see them in different ways, different agendas that may be well known for some of us. In transparency, we talk about the access to public information, the publication of different types of declarations, the elemental ideas of the different parts of this. And in citizen participation, there were some parts of the judiciary that were related to going to the territory, listening to the citizenship. In Costa Rica, there is a good show called Justice Go to School, in which the people from the Supreme Court in Costa Rica went to the different territories and they had conversations with the schools, with the students, and also with other organizations. In some cases, they did some surveys for citizen satisfaction for them to know how was the perception of the people of the justice system, because there was a really low level of reliability. And also the public hearings and different tools that have been advancing in these areas in the region. And in collaboration, maybe we have very few experiences. The Supreme Court started working in the different portals where they put the information for the audience, but there was no space of collaboration per se. And this agenda became stronger, it started to improve. And right now we see a new generation of open justice reforms. These are clearer, more compact, and more established. And in transparency, we talk about active transparency, we talk about open data, we talk about the implementation of different standards, open contracting. In the judiciaries, there are different judiciaries that are working on this. We talk about the use of data, evidence-based policies, accountability based on data as well. And in terms of citizen participation, the agenda has exploded in a certain way. We have clear language, the use of social media, which has been very important to reach the citizens with the judiciaries, and the processes of strategic planning, where the processes are open for the intervention of the citizenship. And we have different classic areas. And in collaboration, I think that we have new tools, new stakeholders. We have the innovation laboratories, our models of public innovation that come from the executive branch and that are now being used in the judiciary, the use of social media in a more collaborative way where they involve citizens more. And the citizenship is using right now social media for everything. And then we have some networks in the region, the networks for the organization of the civil society. In my case, I represent the network for open justice, but the idea is to generate knowledge, to share it, and strengthen the capabilities of the judiciaries in the region. I don't seem to sound like I am overly optimistic. I know that we are living very difficult things in terms of this open government and the civil space, but I want to share that there is a group of reforms and knowledge and we need to make an effort to document it and to put it at the disposal of the justice systems in the region, because many times we hear with a great concern about the lack of knowledge that there are different reforms that have not been implemented, but in the region there is a space of reforms that have been applied, and it's necessary to collect them so that they can be used by the community of justice in the region and in the world. Amazing, Alvaro. I think that this allows us to compare the challenges for the implementation of these principles with practices that may not exist currently. And for this, Carmen Nava, Maria del Carmen Nava, is a specialist in the theoretical and statistical application for the creation of theoretical models in political sciences. She studied in Washington University in San Luis. She was the coordinator of Transparency for Open Parliament in the Assembly of Mexico City, and she is right now the Citizen Commissioner for the Institute of Transparency and Access to Public Information, Data Protection, and Accountability in Mexico City. Maria del Carmen, it's a great pleasure to have you here in this panel and being able to hear you, how your ideas are about these topics. Thank you. Thank you very much to Mexico Evalúa and Frederick Newman Foundation for the invitation to this forum. I think that it's very important and timely to spread the information about the different areas in the state, and the judiciary has its own logic, such as the legislative and executive branches, as well as the autonomous institutions in the state. Thank you very much for the invitation to be with you, Maria, Alvaro, and of course, Justice Margarita, and with your facilitation, Jorge. Thank you very much. I would like to take a step back. How did we start talking about open justice, for instance, through public hearings? In the case of Mexico, as we all may know, just in 2020, we had a reform so that we could have this obligation of making all public hearings transparent, because before they were only based on the decision of the people or those that were of public interest. And since 2015, they had this idea of the obligation of transparency in the Mexican case. With this reform that was applied nationally, basically all the states need to make their hearings public. And in this framework, we are working in Mexico. And I would like to talk about a wide spectrum of justice, of open justice, which goes beyond the judiciaries, as you were saying at the beginning as well, Jorge, about what other institutions of the state are involved, not only in the administration or in the creation of justice, but in the decision-making that imply a warranty, an application, and a human right, or have a certain relevance when looking for solutions for the conflicts. And in this regard, this wide spectrum includes the general attorneys, the human rights commissions, and the autonomous organizations that need to guarantee transparency, as well as the election courts. All of those that are looking for public authorities to contribute with the responses and resolution of conflicts among people, authorities, and groups, as well as communities. In this case, I think that we need to go towards having an open justice in this wide spectrum. I think it's very relevant to have this uniformity of what these institutional politics or policies are in that, as we mentioned in the beginning. And I wouldn't say only in Mexico, but in the world. After 10 years of OGP, as Maria mentioned, is to take these important elements of institutional openness to the daily exercise of the institutions, as well as for the public decision making. And what are the criteria to make decisions, to analyze public policies, if this is related to the interaction and mapping of social needs that through the collective intelligence may be leveraged to make decisions and to take timely and to give timely responses. I think that in this regard, we have developed an open justice panel where Mexico Evalúa worked along with Tojil and also Justice González Alcántara. Also Mexicans Against Corruption and different groups where there was a collective interest to boost these steps of having more open justice. And in this first intervention that I have, I don't know if I have enough time, but I would like to mention, especially about a case that we had and we made public, because sometimes we talk about institutional opening, but the response is how? How do we do it in a simple language that makes it accessible and with a feasibility logic according to the resources, both administrative and in budget or in human resources that we have. And in the Commission of the National System of Transparency, we did a guide according to the International Network of Open Justice. And thank you very much for your contributions to this cooperation guideline that uses this simple language and makes it accessible for the rulings. And this is a tool that we are making available on how we establish this opening as in a document that is important for the administration of justice through public hearings, and both in the jurisdiction, as I was mentioning, in this wide range of justice, in such a way that I think we are moving forward in this expansive way of having institutional opening. And the idea is of contributing with these good practices and documents that may be useful for different communities. Thank you very much. Thank you, Maria del Carmen. I want to also use this panel and this space to share an experience that we are encouraging from Mexico Evalúa, which are exercises of dialogue and feedback on the development of the criminal justice system locally. And we are taking the approach and the principles to take advantage of this. Even though we are focusing on criminal areas here, we perform an exercise in which part of the results to the assessments that we do every year and for which we give our reports. Since last year, we are creating local findings, and we have analyzed in a more detailed way the criminal justice system works in different areas in the country. And starting with that, we start creating an agenda and then a series of topics that are addressed directly with the authorities of the justice system. From that, we generate commitments and we do a follow-up of those commitments. And once they are set, the idea is for them to have improvements, and these improvements should be seen in the next assessments. This was an exercise that we did since last year, and we are replicating them this year. For us, it's very important to follow up these processes, and it's also a way of understanding open justice and also for taking it into practice. And something that Maria del Carmen and Alvaro mentioned is that these are methods that allow us to understand and apply these principles, especially with this approach of generating knowledge, of generating learnings that at the same time are part of this type of approaches. We are going to have a second round in the same order as we did the first time. And here I would like us to focus on the practical part. Some of you have mentioned some elements, but I would like you to help us understand in a more specific way the how to put in practice this open justice model, and how would that be different from a traditional model in the justice system. Where do we have this breakthrough in different practices or in different aspects of the exercise, especially in the judiciary area? And on the other hand, what is the role of the citizens in a process of open justice? We know that there is a diversity of expressions in terms of the citizenship. We have the users of the justice systems, we have the associated, because the associated parts because of all the things that we have, and it is worth reflecting on the role of these processes of openness within this judicial area. And Justice Maria, you have the floor. Well, in judicial terms, open justice has three axes. a judicial governance that would identify the judicial procedure itself and rulings themselves. The rulings is something very delicate, and I am going to focus a little bit more here because judges not only decide on the specific cases, we create opinions. Judges create a speech and they establish values, what is allowed, what is not, what is abusive. And it is important for lawyers and for social anthropologists and political scientists. This is also relevant, and it's fundamental to know them, not only to give society reliability on the fact that what is being decided in a good way. It's the right to justice that I was mentioning, which is according to law. But they also need to know what type of law it is, socially speaking, what is accepted, what is allowed, why is it useful for us to know this? I think that this goes beyond this partial justice, beyond going to public speech, but also to implement public policies. What needs to be corrected? What are we missing? So I think that this is something where we can talk about the hierarchy, the organ, its known dimensions, but we need a lot of things about the judicial order. We have local hearings in the family area, and we may know a lot how the family law is applied in different areas, how many cases are because of divorce, or how responsible we are from our children. And when we're talking about alimony or divorce, if this information is being managed with statistical demographics, we have judicial issues, but we also have public policies. So what are we missing here? I mentioned that we have two ways, local and federal justice, and there is also a document that I thought was very important when I saw it. It's called Injustice Open for Women, where they are comparing the different entities in Mexico on how much access do they have to rulings. Some states of the country know that some of them are of public interest, but they do not publish them. And Maria del Carmen was saying that according to the reform on August 13, Article 73 of the General Law of Transparency, what is this going to mean in the publication of rulings? This is going to take necessarily to a new knowledge or a systematized knowledge of the sentence of the rulings. Who is going to do this? Who is going to handle this? So in this regard, the same way there is this in the judicature, in the judiciary, we need to talk to the society, and this understanding is reciprocal. The judiciary resolves, the judges, everyone is participating in the resolution of a matter. We are using our time and our capabilities, but also who is going to order it, to organize it? How is it going to be disseminated? Not only the resources of the human resources or material resources. So I think it's amazing that this general law of transparency was reformed, but also I think it's necessary to know how to apply it into reality. And also, it's not only about the judiciary or the judges, but also the academy, because the lawyers that work in the judiciary and giving them their intelligence and their knowledge, they are not used of using a plain language for the citizens. And with these practices of governance, there is an issue that we need to apply, and that's where we need this participation of the general society. And that's what we need in this language during these decisions. And that's why we do not necessarily have this easiness, and we need this type of decisions, and this generates a lot of work. So we need a participation that is really robust and round with the academies and with the judicial institutions, so that this education is not a double work for all of this. So I am optimistic, and I would close about this. And I think that this reform is very good in the judiciary. We're moving forward. And then yesterday we received 2 prizes in the contest by the INAI and the authorities on innovation regarding access to justice and transparency. About the search for solutions for human rights that are easy for people. And starting with COVID, we had all of this that was very well accepted to process the electronic signature and to be able to have a judicial process electronically. And I think that this main point is the organization of the information. And I think that I will leave it like that. Thank you very much. Yes, it's a very interesting way of presenting this, on how to do all of this a reality and take advantage of this openness. And continuing with this topic, Maria, can you please share your remarks on this? Thank you very much, Jorge. I think obviously you asked the million-dollar question, how to do it. I think that I would split this question in 3 types for an answer that I think one relates to the other. And obviously it's partially and totally open to debate. But I think that the first thing I would like to say, in the legislation directory, around every 6 months for the last 3 or 4 years, we have made small questions, I cannot call it a survey, to different organizations of the civil society that work in the different countries that create the GPs in Latin America. These are questions to our colleagues, essentially. And every 6 months, we ask them very specific questions that are related to their work in this community. And there is always one question that is related to what is the darkest power of the state? Or we vary this question. What is the one that has the lowest influence, or where there is a least rate of response? And as we were saying at the beginning with the data in the Latino Barometro, in all the questions, the judiciary is the one that receives the worst rating by our colleagues in the civil society. So I think there are more problems for working with the judiciaries in any of their institutions than other branches.
I think that in here we have got some important data mentioned by everyone, and it's the little access because of 1,000 reasons, but there is a specific access, poor access for the civil society to be able to participate. Number 2, stemming from this, I think that because of that reason, there is a very interesting project that about which Quechua Alvaro will tell us, which is called Who's Lab, which was generated in the Council of the Magistrature of the city of Buenos Aires. It's at a subnational level. And in here we were speaking about this, the access for the citizens in general to the judiciary, and what the legislative branch is, what its institutions, stakeholders, actors, the data are, and what the regular, classic, traditional model of a cause at the judiciary. All of this for the citizens in general is this is a dark, this is a question. And I think that this is a very interesting project that tried this from its basis, like the justice was already saying, the language of the judiciary, for a caste that belongs there too. And if you can Google it, I would do it. And what this project has is that it has a call CSOs, the journalists, the academia, you were speaking about them before already. And the next point stemming from this, and this is the work that we conduct from the steering committee of the Alliance for Open Government. And this one concerns the level of creativity that we must have as organizations, as activists, as civil society activists to address this type of topics. It's no longer as it was before, promoting a law or speaking to a legislator. We have had to become more complex in our initiatives so that we want to specifically with what concerns the judiciary, but also with regards to other institutions. And just to mention some experiences, which is one that we have developed, and this is how I'm going to be finishing. There is experiences that we had throughout this year within the JT committee, which is a call to action, and we tried things that we hadn't done before, and we tried initiatives that no one before had advanced, just to see whether the result would change. As we say, we always do the same thing. Nothing is going to ever change. And this entails to phone call. Traditionally, the governments that, we made a selection of 6, but those that are part of the steering committee of the OGP to ask them with the agenda, with the agendas of their countries' organizations, to see what the changes that they could specifically do with regards to those topics were. And the questions, and I'm sorry, the calls here were for justice specifically, that relationship that is very useful. And we have a lot of questions around this, is the relationship of international dialogue with domestic dialogue, and those bridges that can be established with regards to the two from the perspective of different stakeholders has worked very well, and we have had a very good results. Nigeria and Kenya. Unfortunately, we have no Latin American country there at the steering committee. Otherwise, we would have done it with them as well. Data, we have got examples. Alvaro was saying this, whose lab is is a quintessential example of this, and we can be creative as to move forward and to have an impact on these initiatives. Thank you, Maria. Very well. So now let's go move now to Alvaro Herrero, and we will continue down with down the same line. Thank you very much. I agree with most of Maria's and the justice's analysis. I think that the judiciary has got a structural problem, which stems from its historical configuration of the judiciary in Latin America. The legacy of the Spanish tradition was a dispute resolution system, neutral third party, which was going to solve disputes between two parties. And this has an important role in the city because it is going to create a governance and social peace. However, with time, the judiciary changed with regards to their powers, their attributions, and we all know that the constitutional reforms which were broadening the judiciary's powers, the extension of rights in Latin America and in other parts of the world. And today, the judiciary is not only solving disputes today. This is a state power branch. It exercises power, and it has got power to contribute to the realization of rights, not just through its decisions, but it has got other tools and ways to contribute in the generation of equality in the society, the protection of fundamental rights. It can design its own policies in many aspects, gender, environment, housing, and we see how the judiciary today is ever more somehow they look ever more, and I'm going to say this with quotation marks, to the executive branches for some topics. So for the judiciary, in order for it to get closer to the citizens and to refer to the negative image it has throughout the region, and I'm saying this being part as well for the judiciary, and having worked many years in justice, those of us who were inside, we know what is being worked inside the judiciary. We have a constant engagement by the judicial actors. However, the image is still negative. With the we still have a bad image of the judiciary's activity, and we are here in a justice paradigm focused on justice, what justice means and what people center justice means, and we have said this out of this conversation. This justice spoken in a language which is understandable for everyone, clear language. This is a justice that will make decisions as a power based on data, on evidence. And if the judiciary wants to solve the problems of access to justice, it has got to consider which data are out there that account for the social needs, the violated rights. The judiciary usually does not usually do that. This is central to justice, and people-centered justice is egalitarian justice. Today we have topics that are at the center of the public conversation. For instance, the gender agenda. The judiciary cannot only protect women, girls, and adolescent women through its rulings. It can design structural policies to bridge its own gaps within the judiciary, and then go out into the society and lead a social change in gender matters. Today, we are seeing with the Castro Agreement a change of paradigm in matters of environment law and access to the environment and to justice and environmental rights. And the judiciary has a lot to do here, and it can learn from its own experience in other analogous fields on which it has worked together with the civil society. We have to work on how to connect the judiciary to the people. We have to think from the judiciary how to open this up. This is not to be a request by the citizens, by civil society. The judiciary has to set as a core goal to open up to society. Maria was showing whose lab experience in the magistrature of the city of Buenos Aires, and in here we try to solve problems, disputes which are related to the functioning of the judiciary and the protection of rights with the tools of an innovation lab. So when we think about solutions, not only we are going to be listening to the operators of the judicial system, but we're also going to be listening to the society stakeholders, the academia, the journalists, the CSOs, and that's what opening the judiciary up means. So, and that is, we have to stop thinking that the intelligence only on the judiciary side. We have to go out, look for that intelligence, and we have to start connecting neurons. So this is not just a matter of random. We have to generate coalitions, alliances to generate the knowledge that we need, so we can achieve that structural change within the judiciary. Today we have the judiciary planning in a participative way. We have very few cases, but we can use their experiences and take them to all the region. We have to think of a people-centered judicial system and what it means, and that's the main challenge that we have today. So we can make people fall in love again with the judiciary. Great, thank you very much, Alvaro. There is a lot of work to do, and a long way that we have already walked, indeed, with this knowledge that has been generated. Maria del Carmen, the floor is yours now. Thank you very much, Jorge. And well, I am listening to what you are saying, and yes, we have huge challenges, and something that Justice Margarita was saying with regards to the classification, to the operationalization of these transparency norms. I think that there are countless steps here to take, because we are speaking even about in terms of decisions in writing, but also criminal sentences that are recorded in video. And because of the orality, because of orality purposes. And in here we have to see how we can take one step at a time, so we do not overwhelm ourselves with what the institutional openness entails. Without a doubt, this is a way in which we can exercise the state institutions in a democratic rule of law, and I think that we have to take that into account, because institutional openness entails daily activities, not just the formalization of a pact or the execution of an engagement, but how we operate on a daily basis out of the state institutions, how we make decisions, how we document, how we can apply not just this right to know, but the right to understand, and the use of simple, clear, regular language. And language is also an important tool to generate inclusion, to have and to facilitate trust from people in institutions. And I think that open justice can be an important benchmark to contribute to the construction of a positive peace culture. Let's remember that anything that entails a search for the solution of a dispute, from the moment we have a dispute, we're going to be looking for a solution either by the judicial pathway, the judicial powers, and all of these broad spectrum of the justice administration institutions, in such a way that we have a huge opportunity to harness open justice for decision making and the daily operations from any level of structure, any level of bureaucratic institutions. And I would like to comment on a couple of tools that can facilitate this articulation, what we have in terms of open justice, because at the Commission of Transparency and Open Justice that I have the honor to coordinate domestically from the last year, we elaborated a newsletter concentrating different open justice materials. And in here, we are making them available, and they are publicly available in terms of any good tools. And then we can move to open justice. And also there is an article that we shared on how or under which circumstances open justice and democracy are today. And there is a journal, which is a new journal this year, so we can disseminate the challenges in this subject in the country. There is an article of open justice focused on democracy that is a very that it would be important to consider. And finally, how can we return to this step-by-step basis of small actions, between quotation marks, and the work with vulnerable groups, and how can we approach open justice to them? In the case of Mexico City, we work with women inmates, CIS and trans women, and we are detecting not just needs and articulating this narrative of offering solutions, collaborative, multi-stakeholder, multi-level solutions, and we have elaborated a guideline for identity transfer that will allow access to a different type of human rights exercise and guarantee. That's one example of how, with very specific actions and with no specific needs, we can take steps little by little in open justice in such a way that we can focus on how we can move forward and how we can what are the means we have to do this. And once again, thank you very much for this opportunity to be at this table with you. Thank you very much, Maria del Carmen. I want to thank, because we have run out of time, this topic. It has a lot of things about which to discuss, and not just in theoretical terms, now with regards to experiences, practices, and above all, with regards to experiments, models, and the projects that are being promoted today in terms of open justice. We have one task here and a very important matter here, which is that of judicial decisions, how to go from transparency to the generation of knowledge, public useful knowledge. and also the role of or the task of the identification and raising awareness before the stakeholders and the institutions of the judiciary with regards to all the revolution that open state means, not just in terms of judicial governance, but in terms of specific actions according to their functions. So we want to thank the public who was following this panel and who shared some questions with us. We're going to convey them to the panelists for them to follow them up. And once again, I want to thank the participation of Justice Margarita Rios for that, Maria del Caminava, Alvaro Herrero, and Maria Buran for having shared their knowledge and their experience with us in this space. Thank you very much and have a great afternoon.